We're going to talk about Immigrant Legal Center, the nonprofit I work for. We're going to talk about traditional medical legal partnerships. It sounds like there's some foundational knowledge there, and then spend the bulk of our time talking about immigrant-focused medical legal partnerships, or IMLPs, which I know is a mouthful, and how an IMLP can assist you all in serving the civil legal needs and immigration legal needs of non-citizen patients and family members. So first, a bit about ILC. We are the region's largest nonprofit immigration legal service provider. We have 21 attorneys on staff providing legal services, education, and advocacy. We have 9 offices across Nebraska, from Council Bluffs to Scottsbluff, headquartered here in Omaha with a significant office in Lincoln. And we focus on family-based and humanitarian forms of immigration relief. So not employment-based or student visas or visitor visas, but humanitarian and family-based. And really our specialty is the lengthiest and the most complex humanitarian and family-based benefits. So things like asylum, removal defense work, special immigrant juvenile status for kids who've been abused, abandoned, or neglected by one or both parents. Because of our deep bench and our significant experience in this area, we are able to focus on those really time-intensive, lengthy cases. So a bit about MLPs, traditional MLPs, right? Medical legal partnerships integrate lawyers into the healthcare setting to help healthcare providers and staff address the social determinants of health, which you all are probably more familiar than I am as medical social workers, right? But legal interventions can effectively address education, access and quality, healthcare access and quality, concerns with neighborhood and built environment, social and community context, and economic stability. So kind of those core tenets that we know are social determinants of health. And we'll be talking today about how immigration status is likewise a social determinant of health, but unfortunately it cannot be addressed typically by traditional MLPs. So MLPs can address a variety of patient concerns, right, through interventions in a variety of civil legal areas. These are some of the concerns you all may hear from patients that could be addressed by an attorney. And I believe Methodist has a medical legal partnership with Legal Aid of Nebraska. Is that correct? I don't know if you all can even unmute, so I apologize if not. So these are some of the legal problems that a traditional MLP could address, right? I think most commonly we see bankruptcy and debt relief. Adult guardianships are frequently necessary to facilitate a patient's discharge from the hospital. Also, family law issues if there are circumstances of domestic violence or child custody issues. And then I think probably the bulk of traditional MLP work is addressing benefits access and health coverage access, right? Improper Medicaid or Medicare denials or reductions in awards of SSI or SSDI. And then I think a good amount, and probably particularly during the pandemic, a good amount of interventions to facilitate safe and secure housing. So traditional MLPs can both improve the patient's quality of life by helping to meet their basic needs and removing barriers to accessing medical treatment. And they can also have the ancillary benefit of reducing uncompensated care costs for providers by allowing providers to recoup uncompensated care dollars once benefit access, Medicaid, Medicare access is achieved. And then on a future looking basis, right, by providing folks with the coverage they need to access preventive care, right, to prevent folks from relying on the emergency room, which we all know is more expensive than earlier preventive care. So this is really where my expertise comes in. Most traditional medical legal partnerships are run by legal aid organizations that receive Legal Service Corporation funding. That's federal funding for civil legal services. And because it is federal, it is restricted. So it's not allowed to be used for serving most non-US citizen categories. So this means that undocumented patients and their family members and most other categories, even lawfully present immigrants, cannot rely on the services of traditional MLPs. So an IMLP, Immigrant-Focused Medical Legal Partnership, that is funded separately and does not receive Legal Service Corporation funding, can complement a traditional MLP and fill that gap with respect to civil legal service needs for non-citizen patient families. And I'm saying patient families because frequently it is not the patient themselves that we're representing. Maybe it's a guardian seeking guardianship over the patient, or maybe it's a parent of a US citizen patient, but the immigration legal need of that close family member or guardian directly impacts the patient's healthcare access in some situations and health outcomes and quality of life, right? So in making the case for an IMLP, we know that immigrant families and mixed status families, so families that have both US citizens and documented or undocumented immigrants, they all face the same sort of health harming legal needs that US citizen families face in those same arenas: consumer, family, health, benefits, housing. Additionally, they often have a threshold legal need to have their immigration status addressed, right? Or the lack thereof. Many immigrants, both lawfully present and undocumented, encounter immigration legal needs that interfere with their ability to access affordable healthcare coverage. And I noticed the 2018 data was in your Kahoot poll. I just updated it in this presentation. So in 2020, about 25% of lawfully present immigrant adults and over 40% of undocumented immigrant adults were uninsured, compared with just 8% of US citizen adults. That's from Kaiser Family Foundation. Why do we see these high uninsurance rates in the immigrant population, and particularly among undocumented immigrants? One reason is limited access to employer-sponsored coverage. Immigrants, particularly undocumented folks, are often employed in low-wage jobs and industries that are less likely to offer employer-sponsored coverage. Also, just on the whole, they're more likely to have lower incomes and therefore are less likely to be able to afford private coverage through the individual marketplace, which is very expensive for anyone, right? There are also very few immigration statuses that provide access to Medicaid coverage, to full scope Medicaid. And there's typically a 5-year waiting period for coverage to kick in after an immigrant acquires a qualifying status, a Medicaid qualified status. Most lawfully present immigrants can purchase coverage through the ACA marketplace and may be eligible for subsidies, but the majority don't apply. And that's largely due to enrollment barriers like fear, difficulty navigating enrollment, and language and literacy challenges. And then undocumented immigrants, about 40% of the immigrants in the US are not eligible for Medicaid other than emergency Medicaid or coverage through the marketplace. And many of these individuals don't have a path to lawful status in the US or even to a work permit, just because of the way our immigration laws are structured and the very narrow paths that exist to obtain lawful status. And then we see that even when immigrant families qualify for a public health care benefit, they tend to underutilize such benefits due to fear of negative repercussions. So for example, about 8% of Medicaid eligible US citizen children of non-citizen parents are uninsured because they haven't been enrolled in Medicaid. So these barriers to affordable healthcare drive up health disparities for immigrant populations and increase uncompensated care costs for providers. IMLPs can help. So the ways in which an IMLP may be able to help include representing an immigrant patient client in obtaining a work permit or some form of lawful status that provides access to employer-sponsored insurance or coverage under the marketplace, and education and empowerment around how to access those forms of coverage. In many cases, a patient, I say many, but there've been a handful of cases we've seen where a patient actually already has an immigration status that provides full scope Medicaid coverage, such as refugee status or lawful permanent residency that they've had for more than 5 years, but they don't know how to verify or obtain evidence of their status in order to make the Medicaid application. So that the IMLP attorneys who are specialists in immigration law can obtain copies of the relevant documentation to support the Medicaid application. In some cases, we may be able to assist with obtaining a form of status that provides immediate or eventual access to Medicaid, SSI, or another benefit, although that's relatively rare, and I'll talk a bit about the categories that qualify for prompt access to full scope Medicaid. And then even when there's no immigration option, and unfortunately that's frequently the case, IMLP attorneys can provide really critical know your rights and safety planning information that can help empower immigrant individuals and families to seek healthcare services and advocate for their healthcare needs with less fear. And finally, IMLP staff can reassure immigrant families that they can safely accept Medicaid coverage and other benefits for US citizen children who qualify without negative immigration repercussions. So one final way in which IMLPs can help: as access to affordable healthcare options expand, immigrant patients increase their health literacy and make greater use of preventive care, driving down costs, right, to both the patient and the healthcare provider. So Immigrant Legal Center has 3 IMLPs currently. In 2017, we initiated programs with One World and Children's. And in 2019, we formed an IMLP pilot program with Nebraska Medicine and UNMC College of Public Health. And this third IMLP included a study component managed by the College of Public Health to track healthcare outcomes and provider cost savings realized through the IMLP. That study just concluded, and we've done one journal article, which I think is cited in your all's materials, describing an IMLP, describing the components and how funding occurred, and successes and pitfalls in this particular IMLP. And then I believe it also summarizes our preliminary data on reimbursements and cost savings, and I'll be talking about that a bit later as well. So I'd like to walk through, and this will be a long slide, but I'd like to walk through how an IMLP functions in practice. So the first step on this flow chart is outreach by ILC staff with providers, social workers, and financial counselors at the partner healthcare provider to make them aware of the partnership and how to refer a patient. Once referrals begin, staff can refer, patients themselves or immediate patient family members who identify as having an immigration status concern for a legal consultation with ILC. And we'll talk a bit about how to go about identifying and about patient disclosure later on, but a referral could be made because the patient or family self-discloses the need for services, or simply because the staff suspect, based on no Social Security or a Medicaid denial, and affirmatively offer the services. And at most of our partners, the healthcare providers will usually make a referral to medical social work department internally to make the referral to ILC. And sometimes we have financial counselors making referrals as well if they identify the need for assistance later on when they're assisting with a Medicaid application following services. So the healthcare provider staff will make a referral to an Immigrant Legal Center paralegal that runs our intake hotline. That is called the Nebraska Immigration Legal Assistance Hotline, or NELA. And our final slide has that phone number. The intake paralegal will conduct a brief screening and then schedule the patient for a consultation with an ILC attorney. And the consult can occur at ILC, it can occur on site at the healthcare facility, or at a third agreed upon location. We've met with folks in libraries in their home community, and we do have a presence across the state. So we really try to go to the location that's easiest for the patient, client, or family member. So there can be several results from the consult here coming up to this column on the right. Possible outcomes of the consult are that the attorney determines that the patient has no option for immigration relief at this time. In that case, we'll be providing know your rights information, safety planning assistance to prepare for a potential detention or deportation in the family. This could include things like a temporary delegation of parental powers, advising on the need to gather medical records for potential deportation defense case that relates to the medical needs in the family. Safe or know your rights information, I just glossed over, but that could include information like advising the patient client on the fact that health clinics are sensitive locations where ICE, according to its own internal policy, does not conduct immigration enforcement actions, which can help folks feel more safe accessing healthcare services. So if we determine through the consult that the patient client has a non-immigration related civil legal need, perhaps a family law need, or housing or bankruptcy need, medical debt need, we would most commonly refer them out. We do not generally handle other civil legal matters beyond immigration law, with some narrow exceptions. We do handle family law matters, so custody or dissolution, or guardianships, typically where there is some immigration benefit that can be pursued through the entry of that state court order. So we do handle, for example, adult guardianships frequently that are referred through our providers. Legal aid is not able to handle adult guardianships if the prospective guardian is undocumented, because that, even if the ward has citizenship, right, the intending ward has citizenship, the prospective guardian would be the client for purposes of that guardianship, and their legal service corporation funding restricts them. So we handle adult guardianships frequently, but most commonly we're going to be trying to connect them with pro bono counsel to handle the non-immigration civil legal need, or referring them out to another nonprofit who can serve them regardless of immigration status. So for example, for protection orders or domestic violence related family law needs, we might refer to the Women's Center for Advancement. Another potential outcome of the consult is that we figure out that determining their current status or determining eligibility for an immigration benefit requires filing something called a Freedom of Information Act request, or a FOIA request, to request a copy of the individual's records from the immigration agencies. It also might be necessary to do an FBI background check or other preliminary research, right, in order to properly advise them. And then it's possible that we will identify that the individual has an immigration option, but not one that will provide prompt access to Medicaid or other form of healthcare coverage. We will take on these cases regardless of the fact that there's no healthcare access benefit, right? Because we know there are other benefits based on, you know, our capacity. And then some patients, relatively few to be honest, but some patients have an immigration option that can provide prompt access to a work permit and employer-sponsored coverage to eligibility for coverage under the ACA exchanges or to full scope Medicaid. So following the consultation, with the patient consent, the attorney can request supporting evidence to support in any immigration application from the doctor, the medical social worker. We can also inform the referring staff member of whether an immigration option was identified and how long it's likely to take, and what healthcare eligibility might result. I think it is important to emphasize that immigration processes in general move very, very slowly, and processing times are like worse than they've ever been. So part of what we do is educating our healthcare partners on the lengthy process and why things take so long. Once some sort of immigration status is obtained, we notify the social worker or healthcare partner, and we send evidence of that immigration status to be submitted with an application for healthcare coverage or for benefits. If the social worker or financial counselor who's making that application encounters any issues with Nebraska DHHS in seeking coverage, like an improper denial of benefits, we can and have advocated with the DHHS attorneys to get that error corrected. We can provide education and argument on why a particular immigration status that they may be unfamiliar with qualifies for the benefit. So some tips and best practices on discussing immigration status with your patients, with the folks you are engaging with. I think a lot of providers are understandably reluctant to ask patients about their immigration status. You all may be concerned about making the patient uncomfortable or fearful, or creating the perception of discrimination, or could be afraid that you'd be required to disclose the information to authorities if you collect and document it. But we know that immigration status insecurity, like domestic violence, housing insecurity, other social determinants of health, directly impacts mental and physical health. And then in some cases, such as where like lawful status would provide access to an organ transplant that wouldn't otherwise be available, addressing immigration legal needs could be a matter of life or death for patients. So we believe it's really important for providers to offer patients and their family members who may be facing immigration insecurity access to resources to try to help them address it. And it's not necessary that you all conclusively identify the patient as an immigrant or certainly as undocumented in order to make a referral for immigration services. You can simply offer a referral wherever you see or have a suspicion or see indications of a possible immigration legal service need. So how to go about making that assessment, right? Best practices to minimize discomfort and fear for both the provider and the patient, or the staff member and the patient. We recommend Do not ask the patient where they were born or if they are an immigrant. Do not ask them if they have a social security number or a work permit. And certainly do not ask them if they are undocumented. But do ask whether the patient would like to be referred for an immigration legal consultation for themselves or any family member, where their characteristics or concerns expressed lead you to believe it might be helpful. So maybe they've expressed fear of applying for benefits for themselves or for their children, or concerns about how they're going to pay for their health care, or fear of reporting victimization to authorities. Those could all be indicators. I think it's also helpful to depersonalize the offer. So to offer the referral in case you or anyone in your household has immigration legal needs, because then they're able to accept that offer without outing themselves as needing immigration legal assistance. Maybe it's a spouse or parent, right, in their household. We do recommend that you document the referral internally, in your own systems, of course, but that you avoid including any direct immigration status information that the patient happens to disclose to you in medical or billing records. Theoretically, you could be required to produce that information pursuant to a warrant, although it's highly unlikely that it would come to that, but best not to document, not to record that the patient disclosed that they don't have papers, right? Because that could be used against them. So we're going to talk real briefly about which categories of immigrants can access which forms of healthcare coverage. And we're always a little reluctant to get into the specifics, because we don't want social workers or financial counselors to attempt this analysis on your own. There are a lot of caveats and exceptions to the information I'm about to present, and it's been winnowed down and simplified just for accessibility for purposes of this presentation. But the bottom line is that you all should be making a referral in order for immigration and public benefits experts to conduct this assessment. So with that caveat, right, in general, talking about full scope Medicaid exclusively, we know that access to full scope Medicaid is highly restricted. There are only 7 limited immigrant categories that qualify. And most of these statuses are quite rare, relatively small groups of people in them, other than lawful permanent residents and refugees, right? Most lawful permanent residents also face a 5-year bar, so they cannot access Medicaid for the first 5 years as LPRs. There are some exceptions to that. For example, LPRs who were previously refugees or people granted asylum, veterans and military service members, certain victims of human trafficking, and certain pregnant women and children under 21 are exempt from that 5-year bar once they become residents. In terms of other forms of coverage, again, this chart has a lot of caveats, it's highly simplified, right? And there are a lot of nuances in most of these categories. And this is really partial information on what we see most frequently. But just to give you a sense, the highlighted, the sort of gray highlights here, green highlights, are the most common interventions that we pursue as an immigrant-focused medical legal partnership that can provide prompt access to full scope Medicaid coverage. So a pending asylum application, so somebody who's seeking asylum protection and has not been granted asylum, right, can qualify you for full scope Medicaid, but only if you are a child under age 14. And that takes about 6 months from the time the asylum application is filed to the availability of Medicaid coverage. Another I'll point out is special immigrant juvenile status. I mentioned this is for minors under 19 in Nebraska who've been abused, abandoned, or neglected. In Nebraska, this is probably our most generous full scope Medicaid provision for non-citizens. Upon filing an application for special immigrant juvenile status, a child under 19 is eligible for full scope Medicaid. So that could be as fast as 1 to 2 months through an emergency process from the time we begin working on the case. Naturalization down here at the very bottom. So a lawful permanent resident who would otherwise be subject to the 5-year Medicaid bar that we talked about, if they have the ability to naturalize early, for example, because they got their residency based on marriage to a US citizen, they would be eligible to naturalize within 3 years rather than 5 years. And if they have the ability to naturalize early and become a US citizen, they could obtain access to Medicaid immediately upon naturalizing. So that would be about 6 to 9 months from the time we file the naturalization application. And then one of the categories I mentioned previously, or one of the interventions that has been successful, is simply coming up with the necessary evidence that the person already holds a qualifying immigration status but lacks documentation. So that we've seen that with refugees, individuals who entered as refugees, never became lawful permanent residents, and don't know their immigration status. Or we had one patient client who was in a coma and his guardian didn't have any access to his immigration paperwork and didn't know what status he held. So it could be as simple as coming up with, conducting a FOIA, liaising with local officials, local immigration officials, to get the necessary documentation of somebody's current status, and then providing that to the social worker to make the Medicaid application and have the proper supporting documents. As you can see, there are other interventions that can provide access to the ability to purchase insurance under the ACA exchanges, or access to a work permit that then allows for employer-sponsored coverage, assuming the individual can find a job with an employer that provides employer-sponsored coverage. And then there's some SSI eligibility, although that's relatively rare for most categories. So the upshot is that it's relatively rare that there is an immigration option available that provides timely access to Medicaid, right, to full scope Medicaid, which is the most certain and most generous form of coverage for folks who may not be able to obtain it through the exchanges or employer-sponsored insurance, but it does happen. We're making great time. We're going to have time for questions. But I want to share, just in closing, I want to share a few patient stories of real patient clients who we've seen through our partnerships. We are currently working with a patient with kidney failure. She's a lawful permanent resident, and she's in this category I mentioned of LPRs who got their permanent residency based on marriage to a US citizen. And so she's eligible to apply for naturalization after 3 years with lawful permanent resident status, as opposed to the normal 5, right? The problem here is that she will not be able to pass the English and civics exams that she needs to take to become a US citizen. Her English is not good enough, and she doesn't have the ability to memorize the necessary information even in her native language. So she won't be able to pass either exam. We are working with her physician assistant and doctor to prepare a medical waiver of the civics and English requirements for naturalization. That's a form that U.S. Citizenship and Immigration Services makes available. It needs to be completed by an MD or DO, and they are very, very particular about the contents and the presentation of the information. So lots of providers will assume like this is straightforward. I'll just, complete this in a logical fashion and send the patient on their way with it. But it's likely to be denied unless it's reviewed by somebody who knows what the agency requires. So we'll go back and forth often with providers and with social workers who are liaising between us and the provider to make sure that the medical waiver application is sufficient. So upon naturalizing with this properly prepared waiver, this patient will have access to Medicaid immediately, full scope Medicaid, at least 2 years before she would have accessed it otherwise, which with her kidney failure will make a huge difference, right, in the coverage available for her treatment over those 2+ years. This is another example where we actually have some reimbursement information that was generated through the UNMC College of Public Health partnership. So this was an individual who was not incapacitated, not in a coma, right? But he was hospitalized for an extended period and was then referred to us. And he did not know his immigration status. He had very limited information and even less documentation related to his current status. We knew that he had an outstanding order of removal from about 25 years ago, and that he had entered the United States in the early 1990s. But we knew that he was Cuban, but he didn't know how he had entered and what status he may have held before this removal order. And so we had a couple of theories that, bases that might qualify him for Medicaid. But we conducted a Freedom of Information Act request to get a portion of his documents. And with those, we could tell that he had entered as a Cuban Haitian entrant parolee. And that is one of the narrow categories among the 7 categories that provides full scope Medicaid access. And we didn't have the proper evidence of that even after the FOIA. And so we needed to go to a local immigration official and request a copy of his file or a copy of that particular document from his file, but we were able to obtain it and were able to present it to the social worker to present to Medicaid. And as of this presentation drafting, which I think was like May 2021, the hospital had received over $360,000 in Medicaid reimbursement for this one patient. This last example just illustrates how complex this can be and how limited the statuses that provide access to Medicaid are. So this was a patient client who was hospitalized with acute kidney failure. We were able to very quickly obtain an emergency custody order for her to give her mom custody. She'd been abandoned by her dad, and so she was eligible for special immigrant juvenile status based on that custody order and the findings that the judge entered into the order. And she was able to access full scope Medicaid about 3 months after having been referred to us. So her routine dialysis treatment is now covered, and she's eligible for a transplant, which was not the case previously. But she is approaching her 19th birthday, at which point she will age out of Medicaid eligibility under that category and will need some other options. So we're working on getting her a work permit based on her pending asylum application, which is an alternative immigration remedy we have in the works for her. And hopefully with that work permit, she'll be able to seek employer-sponsored insurance and have coverage that way. So even after obtaining Medicaid coverage, you can lose it based on aging out or a change in immigration status, unfortunately. So in order to make a referral to us, you all will need to call the Nebraska Immigration Legal Assistance Hotline, which is this number right here. It's essentially our internal hotline. Historically, it's also served as a referral mechanism for other nonprofit legal service providers in the community, and we still do occasionally make referrals to Catholic charities through the hotline, but increasingly, Immigrant Legal Center is the only legal service provider that receives referrals through this intake channel. So the number and hours are there, and the hotline will be answered by an ILC paralegal who will gather a bunch of biographic, demographic, contact information from the client, and then offer them a consultation with an attorney, or more likely place them on a wait list for a consultation. Our wait time for a consultation is about 4 months on average. It varies by case type. And then one alternative, I didn't put an email address up here, but one alternative, if the patient is reluctant to make this call, first of all, you all are welcome to sit down and call with them, which is always a great option. But if that's not feasible, we have an alternative where you can email the patient's information to a particular email address. It's imlp@immigrantlc.org. And then the paralegal will reach out to them. All right, so that way you can tell patients, I'm going to provide your phone number to this agency, and you can expect a call from a paralegal at Immigrant Legal Center. The paralegal names, in case you want to provide a name, are Anna, Yesenia, and Darlene. So it will be one of them. But we developed that like reverse referral flow, where we call the patient just to help overcome any sort of reluctance or barriers on the part of the patient to pick up the phone and make that call, and provide, sensitive information at a phone number that they are not familiar with and haven't communicated with in the past. So I'm gonna open it up to questions. We've got a full 10 minutes. I don't know if any came in the chat.
Hi, Anna. Yes, we do have one that came in for the chat. The question is, a patient told me that she came to the United States as a mail order bride, then got divorced. She stated that she has been unable to become a U.S. citizen. How many years does she have to reside in the U.S. before she qualifies?
Yeah, so this would definitely be one you'd want to refer. So I'm thinking potentially there could be a potential human trafficking angle, right? Mail order brides. Mm-hmm. There's certainly potential for exploitation and abuse in that dynamic, right? And contract for marriage, contract for services. And then there's also potentially eligibility under the Violence Against Women Act, which is for individuals who were subjected to battery or extreme cruelty, which can encompass a whole bunch of different types of mistreatment, even things that fall short of physical abuse, who were married to, where that battery or extreme cruelty was perpetrated by a US citizen or lawful permanent resident. So the fact that she was married presumably to a US citizen does not in and of itself qualify her to apply for citizenship, right? But I think under this, self-disclosed mail order bride scenario, it's entirely possible that there is some sort of basis through a trafficking visa or through VAWA. We might discover something else upon consulting with her. And the timelines for all of those are different. So that's that's a great example of one where we would need a lot more detail to assess eligibility, and where there may or may not be a path to citizenship, but we'd certainly want to screen her because there could very well be.
At the small community health clinic, we see many patients without insurance and have programs to offer, but many programs do not accept undocumented patients, such as the Every Woman Matters program and Medicaid. We ask that so we know what services that we can provide. Is there a way to ask about documentation status for this purpose?
Yeah, so this is in reference to screening individuals or trying to make an assessment of immigration status in order to know whether a referral can be made, or in this case, to know about eligibility for other coverage, right? I would say if the program that you're screening for, I'm not familiar with Every Woman Matters, but certainly I'm familiar with Medicaid. If the program requires that you all ask that explicitly, then I think there's no way around that. I think frequently the lack of Medicaid access is detected, or lack of availability of Medicaid is detected through a Medicaid denial. I know at least some of our partners routinely file Medicaid applications for anyone and everyone. And when that Medicaid denial comes through, they can then make the assumption that there's no lawful status unless there's some documentation the patient has that indicates that there is. And then we need to look into whether the denial was improper, right? But I think if the benefit that you're assessing eligibility for requires you to ask that explicitly, then you should. But I would say if you don't need to, right, in order to make the determination you need to make, I would suggest finding a way to offer immigration legal screening, immigration legal services that doesn't require that disclosure, right? So those broader questions: do you have a need for immigration legal services? Do you or anyone in your family have concerns about immigration status? Just anything more general, right? And even if I think folks may self-disclose, I don't have a social security number, I don't have any healthcare coverage. Those can be clues to you to then offer the referral for services. But I don't know that that would be sufficient for your purposes to conclusively determine that they're not eligible for these programs, right? So I would say, obviously, if you need to ask the question directly for your own screening for eligibility, then go ahead and do it. I got a direct message, but I think I'm just going to address it on here, if that's okay. And I'm not going to be able to answer it with the information provided, so it won't be very helpful. But the question was, if a patient has been in the US for over 10 years, is there any hope for citizenship or work visa? Also, what about if there's DV? So having been in the US for over 10 years alone does not qualify someone for a work permit or citizenship in and of itself, right? There is a form of relief from removal, so a defense to deportation if someone is placed in deportation proceedings before the immigration court, that qualify or that requires 10 years of continuous physical presence in the US before those immigration proceedings began. So in some immigrant communities, folks are aware of the 10-year rule, right? And that is what that's in reference to. It's in reference to a particular defense to deportation called cancellation of removal. There are several other requirements for good moral character during that period, a lack of any disqualifying criminal convictions, a US citizen or lawful permanent resident, spouse, parent or child under 21 who would suffer exceptional and extremely unusual hardship. So just because someone has been here for 10 years doesn't necessarily mean they'll qualify for cancellation of removal. And then with respect to domestic violence, there are several forms of immigration status that might be available to victims of DV, depending on the particular facts and circumstances. So one, I mentioned previously, the Violence Against Women Act, or VAWA, for individuals who are or were within the past 2 years married to a US citizen or lawful permanent resident who subjected them to battery or extreme cruelty. Another really common type we see is a U visa, and that's available to victims of certain qualifying criminal activity, most commonly domestic violence or sexual assault, that occurred within the United States and who were helpful to law enforcement in the detection, investigation, or prosecution of the crime. So has to have occurred in the US, and a report has to have been made to law enforcement at minimum, if not more, like testimony in the prosecution of the offense. So we'd certainly want to screen for eligibility for a benefit based on the domestic violence history, and then advise on potential defenses to deportation if the person were to be put in removal proceedings around the cancellation of removal, and perhaps an asylum claim if they're afraid to return to their home country. And I would say in general, a lengthy residence in the US, long period of time, and close ties, close family ties, community ties, employment history, record of paying taxes. Undocumented folks can and do pay taxes. That's only going to benefit someone in their immigration case when it comes to discretionary decisions on the part of the agency, right? So there may be an opportunity to ask for some sort of leniency, for a stay of deportation if it comes to that, or some sort of discretionary benefit, depending on the facts and circumstances of their case. So long time in the US certainly makes the case more sympathetic, but unfortunately there's no direct path to citizenship simply by virtue of having been here for a long time.
If there's no other questions, thank you so much, Anna. That was a lot of great information. I know we could talk about this for a lot longer than an hour, especially with all the questions and the different situations and circumstances. So we really appreciate your time today. Thank you so much, everybody.
That concludes the online education. I would like to thank all of our presenters for their experience, knowledge, and expertise. Be sure to subscribe so you're up to date with all of Nebraska Methodist College's continuing education offerings. Thank you.